Hi guys, this is 𝗙𝗪𝗀. In this class we will be revising inspection, inquiry and investigation from the Companies Act. We have already covered the revision classes relating to directors, operation and mismanagement, and all the chapters relating to economic laws as well. Now we will be starting with inspection, inquiry and investigation. Before revising the chapter, a small information: we have launched test series for paper 4 corporate and economic laws for May 2022 students. You can purchase this test series from our website lecturepedia.in. Okay, now let us revise this chapter. Inspection, inquiry and investigation. We will be having section number 206 to section number 229. First of all, we will understand what is the difference between inspection and investigation. Basically, inspection means general scrutiny to find out whether any fraud has taken place or not. While conducting inspection, the people who are conducting inspection doesn't know whether the fraud has taken place or not. They are finding out, okay, they are checking whether the fraud has taken place or not. That will be inspection. Whereas in case of investigation, the persons who are conducting investigation already know that a fraud has taken place in the company. Now they are trying to find out how the fraud has taken place. That would be the difference between inspection and investigation. Now what is inquiry? Inquiry means asking some questions to expecting some answers to the questions. That would be inquiry. Inquiry is just asking some questions. That would be inquiry. That would be the difference between inspection, inquiry and investigation. Now section number 206. Power to call for information, inspect books and conduct inquiries. Under Companies Act, who is having power to conduct inquiries and inspection of books? Let us see. First of all, you all know that every year companies file their financial statements, annual returns and various other information with ROC. Now once the information is filed with the ROC, after verifying the information, if it feels that any further information or explanation is required, it will further ask the company to provide such further information and explanation. Now all the companies, past employees and present employees, must duly furnish these information to the ROC. It is the duty of the past and present employees to furnish the information which is asked by the ROC. Hope this is clear. Now let's say when ROC asked for the information, they have not furnished the information, no information is furnished, or inadequate information is furnished, or information is furnished but on scrutiny registrar satisfied affairs are unsatisfactory. The affairs of the company are being conducted unsatisfactorily. In that case, registrar by a fresh notice will call for inspection on the company. These are the three situations in which registrar will call for inspection of books of accounts of the company. And also even central government is also having power to call for inspection. Central government will appoint inspector for conducting the inspection of the company. Hope this is clear. That is relating to inspection. Now power to conduct inquiry. Who is having power to conduct inquiry? Registrar. First of all, registrar is having power to conduct inquiry based on the information that is furnished by the company. See, based on the information furnished, registrar can conduct inquiry, or representation by any person that company is carrying business fraudulently or unlawful purpose. If any person gives complaint or representation to the registrar saying that a particular company is carrying on its business fraudulently or for an unlawful purpose, in that case the registrar can conduct inquiry on such company. Or if the company is not fulfilling or not responding to the grievances of the investors, okay, If grievances of investors are not addressed, even in such case also, registrar can conduct inquiry on the company. Those are the cases in which registrar can conduct inquiry. Now, inquiry by central government. Even central government can also suo motu direct registrar or inspector to conduct inquiry on the company. Hope this is clear. That is section number 206 relating to inspection and inquiry. Next, section number 207, which deals with some of the powers and duties during inspection and inquiry. Let us see. First of all, duty. Duty of whom? Duty of officers of the company. What is the duty of officers of the company? They must produce all documents, statements, information, explanation to the registrar. Whatever the information is asked by the registrar, that must be provided by the officers, and render assistance to the registrar for conducting inspection and inquiry. Next, powers of the inspector or registrar. What are the powers of the inspector or registrar during inspection and inquiry? They are having power to take photocopies of the documents or books of accounts of the company, place identification marks on the books of company, and all powers of the civil court. What are the powers that the civil court will be having? Power to examine on oath, and power to order for producing the books of accounts. All these types of powers which are available with civil court are also available with this registrar and inspector during the inspection and inquiry. Those are powers and duties during inspection and inquiry. Next, section number 208. Okay, the inspection or inquiry is conducted. After conducting the inspection or inquiry, a report will be submitted. First of all, who will conduct the inspection or inquiry? Either registrar or the inspector appointed by central government will conduct. Now, these people will present their report, okay, report of inspection or report of inquiry to the central government. See, registrar or inspector will give the report of inspection or inquiry to the central government. In this report, they can recommend for further investigation into affairs of the company. The report under section 208 can recommend for the further investigation into affairs of the company. Hope this is clear. Next, section number 209, search and seizure of books of the company. Let us see. See, this search and seizure under section 209 is during inspection and inquiry. Okay, section number 209 is relevant only for inspection and inquiry, but not for investigation. Let us see. Now, books, papers of who? Key managerial personnel or any director or auditor or company secretary of the company are likely to be destroyed, falsified, mutilated. In that case, registrar or inspector, after order of special court, search and seize the books of the company. See, during inspection and inquiry, the registrar or inspector feels that the books or papers of key managerial personnel, director, company auditor or company secretary are going to be falsified, mutilated, destroyed. Okay, destroyed. In that case, what registrar or inspector can do is they can ask the special court to give an order for search and seizure of books of those company. In that case, if at all they have seized the books of the company, they must return these books to the company or the company secretary or auditor from whom they have taken within a period of not less than 180 days. Okay, and after 180 days, if at all inspector or registrar further wants these books of accounts, then see, if required further, can call by an order in writing. Hope this is clear. Those were the provisions relating to inspection and inquiry. Now we will be moving into investigation. Relating to investigation, basically we can divide these investigations into four sections. Investigation into four sections. Four types of investigations you can say. Firstly, section number 210, investigation into affairs of the company. 216, investigation into ownership of the company. 212, investigation by Serious Fraud Investigation Office. 213 investigation in other cases. We will discuss each of these sections. First of all, section number 210 investigation into affairs of the company. When the investigation can be conducted? Investigation by central government based on report under section 208. See, under section 208, registrar or inspector have given their report to the central government on inspection or inquiry conducted. Now in that report they can recommend for further investigation into affairs of the company. Based on such recommendation in report under section 208, the central government can conduct investigation. Okay. Or the company in the annual general meeting, shareholders of the company by passing a special resolution decided that the affairs of the company must be investigated. Even in that case also central government will conduct investigation. Or in the public interest, central government itself suo motu can order for the investigation. Okay, those are the situations in which central government will order for investigation. Next, or based on order of court or tribunal, central government will order for investigation. See, even though tribunal or any court wants investigation to be conducted into affairs of the company, they cannot directly conduct. They have to ask the central government to conduct investigation into affairs of the company. Only central government is having power to conduct investigation into affairs of the company. Hope this is clear. Central government will appoint inspectors to conduct the investigation. Hope this is clear. But only central government is having power to conduct the investigation. That is the reason why even courts and tribunal will also order the central government to conduct the investigation, but they will not directly conduct the investigation. Hope this is clear. Next, note, central government will appoint inspectors. Now in this case, where company by passing a special resolution approached the central government for conducting investigation into affairs of the company, in that case a security amount for expenses of investigation must be deposited with the central government. This will vary based on the turnover of the company. If the turnover of company is up to 50 crores, then the security amount will be 10,000. If turnover is more than 50 crores up to 200 crores, then the security amount will be 15,000. If turnover is more than 200 crores, then the security amount will be 25,000. And this security amount will be refunded in case the investigation results into prosecution. Hope this is clear. Next, section number 213, investigation into affairs of the company in other cases. What are these other cases? Basically, this section number 213 is linked to operation and mismanagement. Under operation and mismanagement, the application for operation and mismanagement can be filed by the members under section 244. Under section 241, they can file application for operation, but for filing the application to the tribunal regarding operation or mismanagement, there are various conditions to be satisfied. There are certain number of members, minimum number of members who have to file the application, and also the tribunal should get an intention of winding up, and there are various other conditions that must be satisfied to file application regarding operation and mismanagement. What if those conditions are not satisfied? If those conditions are not satisfied, then the shareholders or any other person who wants to file application against the company can use this section number 213. Let us see. Application to tribunal by, and also the application for operation can be made only by the members, but here application to the tribunal against the company can be made by anybody. Okay, any person can file. Let us see. Application to tribunal by, in case company is having share capital, then not less than 100 members or members holding 1/10 of the voting power. In case company is not having share capital, in that case not less than 1/5 of the total members. Here you can get a doubt that even here also there are certain conditions prescribed. There is a certain minimum number of members who should file the application. Then what is the use of this section? If you see, there are certain two conditions prescribed, but if even though these conditions are not satisfied, you can file application under this third option, where it says application by any other person. In this any other person, even member will also come. Okay, if members are not satisfying this criteria, okay, or this criteria, then they can file application to the tribunal using this option, application by any other person. Hope this is clear. Next, what are the grounds for filing the application for investigation? There are 3 grounds. First ground, business is conducted with the intention to defraud creditors, members, or any other person, or person connected with the formation, management, or guilty of fraud. Okay, the promoters or the management of the company or guilty of fraud. In that case also, application can be filed to the tribunal by any person, or members are not given all information relating to affairs of the company. Okay, proper information is not given to the members. On these 3 grounds, application for investigation into affairs of the company can be filed under section 213. Now, once application is filed with the tribunal, tribunal will order to conduct investigation. See, the application will be filed with the tribunal. First of all, application will not be filed with the central government, it will be filed with the tribunal, and tribunal is not having power to conduct investigation. Thereby, tribunal will order central government to conduct investigation. Tribunal order to conduct investigation to central government. Now, central government will appoint inspectors to conduct investigation. Hope this is clear. Next, if guilty is proved, then officers punishable for fraud under section 447. If the guilty is proved against the officers of the company, then they will be punishable under section 447 for the fraud. Next, section number 216, which is relating to investigation into ownership of the company. Even this section is also linked to operational mismanagement. Under section 241, application for operation has been filed with the tribunal by the members. Now, once the application for operation is filed with the tribunal, now the tribunal has to verify whether the operation is actually being taking place or not, and who is conducting the operation. In that case, tribunal will verify the ownership of the company. See, application under section 241 is filed with the tribunal for operation. After filing the application with the tribunal, tribunal will order to conduct an investigation into ownership of the company. To whom it will order? It will order central government. Now, central government, once the order is received from the tribunal, it shall appoint the inspector to find out what is the objective of this investigation, to find out who are financially interested in success or failure of the company, who are able to materially influence the policy of the company, and who has beneficial interest in the shares of the company. To find out these facts, investigation will be conducted into ownership of the company. Next, section number 222, imposition of restrictions on the securities. Basically, this is additional power that is available with the tribunal during the investigation. Let us see. Tribunal, based on investigation under section 216, that is the one which we have discussed here, investigation into ownership of the company. Based on this investigation or complaint by any other person, tribunal feels that it wants to find certain facts about the securities of the company, and it will not be able to find those facts until it puts some restrictions on the securities of the company. If tribunal feels so, then by order the tribunal can restrict securities for a period not exceeding 3 years. Okay, the restriction on the securities can be placed for a maximum period of 3 years. Next, section number 221, even this is also additional power of the tribunal during the investigation. What is the power? Freezing of assets of the company on inquiry and investigation. There are 4 situations. Reference is made by the central government, or based on inquiry or investigation, or complaint under section 244, that is operation mismanagement, or complaint by creditor having 1 lakh outstanding debt due to the company. In these four cases, the complaint is to tribunal has reason to believe that assets of the company will be disposed and such disposal is prejudicial to the public interest. If the tribunal feels so, then the tribunal will order for freezing of the assets of the company for a period not exceeding 3 years. Even the assets can be freezed for a period not exceeding 3 years. Hope this is clear. Next, section number 211, which deals with the establishment of SFIO, Serious Fraud Investigation Office. Who will establish this SFIO? Central government will establish SFIO. Who will be the head of SFIO? Director will be head of SFIO. This director will also be appointed by central government. See, director appointed by central government, not below the rank of Joint Secretary of Government of India. Such person can be appointed as director of this SFIO. And central government also appoints such number of experts as required. Okay, based on the requirement, the number of experts will be appointed to this SFIO. Section number 212, investigation by SFIO, Serious Fraud Investigation Office. The investigations will be assigned by the central government to this SFIO. Okay, let us see. Central government will assign cases to SFIO. The grounds will be same grounds that we have discussed in section number 210. See, report of registrar or inspector under section 208. Based on the report that has been given by the inspector or registrar relating to inspection or inquiry, the central government wants to conduct investigation, and such investigation is so serious. Okay, in that case, such investigation will be assigned to this Serious Fraud Investigation Office. Otherwise, if the central government feels that this is not so serious, it need not be assigned to the central SFIO. In that case, central government will appoint inspector to conduct the investigation. Hope this is clear. Or a special resolution has been passed by the company, and they have decided to conduct investigation into affairs of the company. In that case also, if central government feels, it can assign this type of investigation to SFIO, or in the public interest, or request from department of central government or state government. These types of investigations, if central government feels, it can assign them to SFIO. Once the investigations are assigned to the SFIO, if at all any other agency is carrying investigation relating to that case, all the investigations that are being carried on by other agency must be handed over to the SFIO. Okay, all the relevant documents must be handed over to the SFIO, and no other agency must continue their investigation in the matter which is assigned to the SFIO. Hope this is clear. And SFIO will appoint investigation officer. Investigating officer will conduct the investigation. This investigation officer will be having same powers of inspector under section 217. Next, officers of the company must cooperate to this investigation officer, and once the investigation is completed, SFIO will give the investigation report to central government. And officer not below the rank of assistant director of SFIO can also arrest person if authorized by the central government. Okay, if the central government authorizes, then the officer can also arrest the person whom he is investigating. After arresting, you have to forward the order and relevant documents to SFIO in a sealed envelope, and also within 24 hours you have to present such person whom you have arrested before special court or judicial magistrate or metropolitan magistrate. This is relating to investigation by SFIO. Next, section number 215, a small section which says that firm or body corporate or association of person cannot be appointed as a inspector. Only individual can be appointed as inspector. Next, section number 218, protection of employees during the investigation. See, now investigation has been ordered in the company, and it was found that a particular employee was responsible for the fraud, and there is a doubt on particular employee or officer that he has conducted some fraud. In that case, during investigation, if company proposes to discharge or suspend any employee or punish him by dismissal, removal, reduction in rank, etc., or change terms of employment to his disadvantage. If company wants to take any of these three actions, then it has to first of all take the prior approval of tribunal. Okay, only after obtaining approval of the tribunal, the central government the company can take any of these three actions. Now, once the application is filed with the tribunal for the permission, tribunal can approve the application. Okay, once the tribunal approves, the company can remove such an employee or any other punishment can be given. Now, if the employee is not satisfied with the order, then he can file an appeal with the appellate tribunal within 30 days. Okay, or tribunal rejects the application filed by the company. In that case, if company is not satisfied with the rejection of the application application filed, in that case company can file appeal to the appellate tribunal within 30 days. If tribunal has not given any response in the 30 days, in that case it will be deemed to be approved, and the company can proceed to remove the employee or take any other action against the employee, and the approval of the tribunal will be deemed to be given. Hope this is clear. And in case any appeal is filed, the decision of the appellate tribunal will be final. You cannot again file an appeal against the decision of the appellate tribunal. The appellate tribunal's decision will be final. Next, powers of the inspector. You can divide the powers of the inspector into three types. First one, section number 219, investigation into affairs of related companies. Section 220, powers to seize documents. Section 217, miscellaneous powers and procedures. Next, see section number 219, investigation into affairs of the related company. Now, inspector is investigating company A. During this investigation, inspector feels that investigation of some other related company is also required. In that case, whether he can carry the investigation of such a related company or not. Let us see. See, inspector appointed under section 210, 212, 213 considers necessary to investigate into affairs of any body corporate which is or was subsidiary of the company of which the investigation is being conducted, or holding of the company, or subsidiary of the holding company of this company. In that case, or is or was managed by a person as a managing director or manager who is was managing director manager of the company. See, let's say, let me tell you an example. There is A Limited. Now, subsidiary of holding of A Limited, subsidiary of A Limited, subsidiary of holding of A Limited. Okay, these will be related companies. And also, now in this A Limited is being managed by a particular manager or managing director, and this manager or managing director is also responsible for managing B Limited. Then B Limited will also be a related company, or whose board of directors has nominees of company and accustomed to act as per the instructions of the company. Now, the board of, let's say, the board of directors of B Limited is having nominees appointed by the A Limited, and the board of directors of B Limited have accustomed to act as per the directions given by the A Limited. In that case also, B Limited will be treated as a related company. Or person who is or was managing director, manager, employee of the company. See, investigation is going on against A Limited, and in A Limited, manager, managing director or employee, these people will also be treated as related persons or related entities. Now, the inspector, if feels necessary, he can also conduct investigation in all these related entities. Hope this is clear. But for conducting the investigation into related entities, he should get prior approval of central government. Hope this is clear. Next, section number 223. Inspector's report. After conducting the investigation, he has to give the investigation report. To whom he will give? He will give to central government, and the report must be in writing, and the copy can be obtained by any member or creditors or any other person whose interest is affected by this investigation. Okay. And the report must be authenticated by seal of the company or certificate of public officer having custody of the report. This is regarding investigation report. Section number 224. Actions that the central government can take based on this investigation report. Once the investigation report is submitted to the central government, what actions the central government can take? Let us see. Prosecute such person who is found to be guilty, or make petition to the tribunal for winding up of such company. If the central government feels that based on the investigation it is necessary to wind up the company, then it will ask the tribunal to make a to give a order for winding up of that company, or application to tribunal to order for dischargement of assets fraudulently used by the director, key managerial personnel, employee of the company. Now, based on the investigation, it was found that the employees or some of the directors or key managerial personnel have fraudulently used the assets of the company. In that case, central government will ask the tribunal to give an order asking those employees or directors or the key managerial personnel to discharge those assets back to the company. Hope this is clear. These are the actions that the central government can take based on the report. Section number 226. Investigations proceedings shall not stop even if application was made under section 241 or company passed special resolution for voluntary winding up, or any proceedings relating to winding up is pending before the tribunal. See, even though winding up is going on against the company, the proceedings relating to investigation will not stop. Hope this is clear. By this, revision of inspection inquiry investigation is completed. I have not discussed one section which was related to this powers of the inspector. That section you can go through, and some 2-3 small sections also I have not discussed. Those sections you can go through. Those are not much important. Okay, hope this is clear.